This is a story of two futures colliding in a courtroom. In one corner, you have Michaela Johnson, a 17-year-old honor roll student, recently accepted into college, with a seemingly bright path ahead of her. In the other, the dark reality of her crime, a terrifying robbery where she, as the driver, allegedly boxed in a mother and her 4-year-old child, leaving them trapped and traumatized. Her mother even took the drastic step of leaving her in jail for 5 months, hoping the shock would be a wake-up call. The defense is painting a picture of a rehabilitated young woman, a good kid who made a single terrible mistake and has learned a profound lesson. But the prosecution sees it differently. They see a calculated act, targeting the most vulnerable victims imaginable, and they are demanding serious prison time. Today, Judge Boyd holds Michaela's entire future in her hands. Will she grant a second chance, or will she decide that some actions are simply unforgivable?
All right, so let's address the case first. What is the...
Right away, the defense is playing for time. They're asking for a 30-day extension on the plea deadline, and the reason is crucial. This is a legal strategy where the defense tries to present evidence to the prosecution that lessens the defendant's culpability or provides reasons for a lighter sentence. In this case, they're working with a counselor to build a profile of Michaela as a 17-year-old who deserves leniency, not a hardened criminal. They're highlighting her youth and attempting to craft a counteroffer to whatever the state has put on the table. However, a major wrench was just thrown in their plans. Michaela, who was out on bond, just got picked up on a new violation. This isn't just bad timing. It completely undermines their argument that she is responsible and can be trusted. The defense is trying to downplay it, but this is a serious setback before the main event even begins.
The reason for for extension of plea.
Judge, I think we're here at the plea deadline date. The state has made an offer and they've invited a counter. So since that offer, we've been working with a counselor. Miss Johnson is 17 years old and we're working with a counselor.
This is where the case takes a bizarre turn that could have massive consequences. The reason Michaela's bond was just revoked is almost unbelievable. She violated her GPS monitoring to go to McDonald's. Her lawyer explains that she was supposed to be at a school course on a Saturday, but it was canceled. She claims she then used that time to pick up food for her hungry younger siblings. It sounds innocent on the surface, but for someone on bond for a violent felony, it's a catastrophic error in judgment. She wasn't allowed to be at the Montage Apartments, Marshall's Meadows Apartments, or the McDonald's in question. Being on GPS monitoring is like being in a virtual jail cell. Every move is tracked, and any deviation from your approved schedule, work, school, home, is an immediate red flag. The prosecution now has a perfect example to argue that Michaela doesn't respect the court's authority and can't follow simple rules.
To see if there's some mitigation that we can present to the state. So she got picked up last week and kind of threw a wrench in our plan to get together with the counselor. So I just asked for 30 days to come back, and in the meantime, I'll talk to the state about a counter offer. She's 17 years old, serious charges, and we're just trying to work out the best possible thing we can. So that's where I'm at on that. And Judge, may we address the bond violation?
Yeah, just one moment. All right, so now the violation.
Judge, I'm trying to understand it. We got notice of it, and I think it went to Judge Angelini, and he remanded Michaela without bond, and she was picked up. So she was, as a result of this case, she was placed in alternative school through the school district. She goes to Roosevelt, and she was attending some school on Saturday. She completed her alternative school, was headed to her course on Saturday when she was notified that she did not have to go to school on Saturday.
And here they're complaining about a McDonald's.
Right. So Michaela can answer your direct questions, Judge, but in a nutshell, she thought she could use the time to go pick up food for her brothers and sisters through her father.
All right, and then what is this with Montage Apartments and Marshall's Meadows Apartment?
Yes, ma'am. So
I'm gonna have to put you on there. Oh, State, are you prepared to proceed on this?
Yes, Your Honor.
You have, you're asking that she remain remanded, or you all have discussed it?
So we discussed it. I think the state wanted to hear from her specifically as to what happened. And ultimately, I think we were going to be in agreement to allow her back on bond with the understanding that she's not to do these things. But we wanted to make sure this is actually what happened.
All right, can you raise your right hand? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michaela Johnson.
Does anybody have any questions?
Judge Boyd is delivering a masterclass in courtroom reality right now. She's not yelling, but her words are cutting straight through the excuses. Her point is simple and brutal. When you are out on bond with a GPS monitor, your freedom is not your own. You don't have the luxury of making personal decisions, even for something as seemingly minor as getting food for your family. The judge spells out the correct procedure. Call your pretrial officer and ask for permission. Her line, "It is not best to ask for forgiveness than permission when you're on paper," is a fundamental lesson that many defendants learn the hard way. She's making it crystal clear that the previous judge already tried to teach her this by remanding her and she didn't listen. This lecture isn't just for Michaela. It's a signal to everyone in the courtroom that this judge is meticulous by the book and will not tolerate any deviations from her orders.
I'll ask Michaela a few questions if I may. Michaela, you've had a chance to read the violation report. You've explained it to me. I think there's some specific addresses that the judge was going to inquire about. So why don't you just explain to the judge what your decision was once you found out you did not have to attend school?
Yes, sir. Once I found that I didn't have to attend school, I had got a call from my little brother and little sister that they were hungry, and I thought I could use the time. So I went to the apartments to grab money from my aunt. And on the way back, I went to the apartments to ask them what they would like from McDonald's, which is why I was at the McDonald's. And I went back. My Uber took a little longer than expected, which is why I was late home.
Okay. Any questions?
No, Your Honor.
All right, did her mom want to say anything to
No,
this?
Judge, I think we've addressed it. I just wanted you to know she has the support of her mom and is residing with her mom.
All right. And Stace?
So Judge, I understand what happened in the violation report. It does seem like her story did make sense. That's why I wanted to make sure that the court was able to hear and make a decision based off of what happened. The state's primary concern, again, we heard all this through her attorney, but it's something that I just wanted to make sure, was this the actual thing that occurred? Also to make sure that the court admonished her and made sure that this didn't happen again.
All right, so you're 17.
Yes, ma'am.
You have to realize when you're on GPS, you're only allowed to do what you're allowed to do.
Yes, ma'am, and I apologize.
So the proper thing to have done would have been to pick up the phone, call your pretrial services officer and say, I don't have school today. I just got a phone call from my siblings. They're hungry. May I go to McDonald's? And guess what? They're either going to say yes or no. When you're on GPS, it is not best to ask for forgiveness than permission. When you're on paper, everything is, you got to ask for permission, not forgiveness. Because I think the previous judge taught you that asking for forgiveness after not asking for permission does not work in court. Do you understand that?
Yes, ma'am.
All
Judge,
right.
I think her mom had called Mitchell bail bonds and they would agree to get back on the original bonds if the court would.
The case is now officially moving forward to sentencing. Michaela has just entered a plea of no contest to the lesser charge of robbery. No contest is a strategic plea. It means she isn't admitting guilt, but she is accepting the conviction and punishment as if she were guilty. The key difference is it can sometimes offer a small amount of protection in civil lawsuits. The plea agreement sets a cap of 8 years. This means the judge cannot sentence her to more than 8 years, but she has the discretion to go much lower, including granting probation or deferred adjudication. Deferred adjudication is what the defense is desperately hoping for. It would allow Michaela to avoid a final felony conviction if she successfully completes a period of probation. However, the state is actively opposing it, signaling they are going to fight hard for prison time. The stage is now set for the final battle.
Consider that.
All right, if you will call Mitchell bail bonds, because I can't reinstate the bond unless Mitchell bail bonds tells the court they're okay with the court reinstating the bond. So you get in touch with them today. What I will do is I'll ask that the bond will be reinstated and you have your previous GPS conditions and you're only allowed to go to school.
Yes, ma'am.
Do you understand?
Yes, ma'am.
All right, so that's not going to happen until I get notification from your counsel that Mitchell is willing to go back on your bond.
Yes, ma'am.
Can I firm that in, Judge?
Yeah, if you want to call them now, you can.
I'll do that.
You're an officer of the court.
All right.
All right, thank you.
Thank you, Judge.
You're welcome.
Judge.
Good morning.
Come on.
Good morning. All right, today is the plea deadline date.
It is, Judge, and we've agreed on a plea and agreement, and we'd like to take it before you formally.
All right, the court is calling 2023 CR 3848, State of Texas versus Michaela Elise Johnson. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Patrick Hancock for Ms. Johnson.
And are you Miss Michaela Johnson?
Yes,
State, are you proceeding on the indictment as presented?
We aren't, Judge. We're going to proceed on the lesser included offense of robbery in count 1 and then waive count 2.
That's
Any
our-
objection?
No objection, Your Honor.
Ms. Johnson, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the lesser included offense of robbery? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine.
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty?
The defense is now calling their key witness, the one person they hope can sway the judge, Michaela's mother, Alicia Franklin. This is a high-stakes emotional appeal. The defense's entire strategy hinges on portraying Michaela not as a lost cause, but as a child who has learned a life-altering lesson and is now on the right path. Her mother is here to provide that personal testimony. She's going to speak to Michaela's academic achievements, her acceptance into college, and her character. But more importantly, she is the architect of the tough love strategy. She's the one who made the gut-wrenching decision to leave her 17-year-old daughter in jail for 5 months. The defense needs her to convince the judge that this extreme measure worked and that Michaela is truly reformed. Her testimony needs to be powerful, sincere, and unshakable, especially with the prosecutor waiting to tear it apart.
And sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Court will
Judge.
find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on the lesser included offense of robbery. Punishment is to be assessed at a cap of 8 years in the prison. State is opposing your application. They're taking in consideration 2023 CR 3850, 849, grand jury number 806632. There's to be restitution payable to John Bright, BRIGHT, of $110 and grand jury number 806632. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State.
Yes, Your
Then to
Honor.
the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states exhibit 1 in all attachments.
No objection.
All right, you may be excused. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We'll come back on February 1st. At that time, the court will make a decision on your application.
This is an incredibly powerful and unconventional move by a parent. The mother, Alicia Franklin, just testified that when her daughter was arrested for these horrific crimes, she made a conscious and deliberate choice to leave her in jail for 5 months. She had the financial means to bail her out, but refused. Her reasoning was brutal and direct. She wanted Michaela to understand the gravity of her actions, to feel the reality of jail, and to learn a lesson she would never forget. The defense is framing this as the ultimate proof of rehabilitation. They're arguing that those 5 months were more impactful than any sentence could be, and that she now understands the stakes. This is a massive gamble. Will the judge see this as a sign of a family taking extreme accountability, or will she see it as a desperate measure that still doesn't erase the crime itself? The mother firmly believes her daughter will never be in trouble again.
Based upon the PSI report and any other information that's presented.
Yes, ma'am.
Judge, may I make a request?
Sure.
Judge, regarding the PSI, can we request that there are 2 juvenile male co-defendants?
Mhm.
Can I request that the PSI include what their disposition of their cases were? And
Usually the PSI will have that in that.
okay,
It'll say whether or not,
I just want to make sure it's hard for me to get that information. So.
sure.
And the second thing is, Judge, I think you'll recall, because we come up before, Ms. Johnson is on GPS to go to school, finish her senior year at school. She's 17 years old. Her grandmother's in hospice, and so she would like the opportunity to visit her on Christmas Day from 12 to 2.
Sure, just speak with the state, grab a B page, and I'm sure they won't have any objection to it.
I'll do that, Judge. Thank you.
Sure. All right, court is calling 2023 CR 3848, State of Texas versus Michaela Elise Johnson. Can I have parties announced for the record for the state? Defense?
Patrick Hancock for the defendant.
All right, and are you Ms. Johnson?
Yes, ma'am.
All right, we're here for sentencing. You entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. State, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Ms. Franklin. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can
Okay.
state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted.
The prosecution's cross-examination is absolutely devastating. The prosecutor systematically dismantles the defense's narrative with a series of cold, hard facts. First, the time of the crime, 1 p.m. on a Wednesday, when Michaela should have been in school. This immediately counters the image of a diligent student. Then the victims, a mother and her young 4-year-old son, confirming the horrifying nature of the act. The prosecutor gets the mother to admit she's read the victim impact statement and that the family was drastically affected. He then lands the most damaging blows. He forces the mother to concede that Michaela, at 17, was the oldest of the 3 perpetrators, and most critically, she was the driver of the car that boxed the victims in. He makes her agree that her daughter should have been able to make better decisions. In just a few questions, the prosecutor has shifted the focus from a rehabilitated teen to the calculated and predatory nature of the crime.
Responsibility for a robbery here in Brick County.
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17,
And when did she turn 18?
November 3rd.
And where is she a student at?
At Roosevelt High School.
What grade is she in?
She's a senior.
And being in Roosevelt High School, has she made future plans, applied to any universities, or done anything at this point in her senior year?
Yes, she was accepted to UTSA, and we're pending.
Excuse me, please whisper.
Say it again, ma'am.
She was accepted to UTSA, and we're pending the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's
This is a critical moment. The judge just revealed a major red flag from the pre-sentence investigation report, or PSI. This report is a background check prepared by a probation officer to help the judge decide on a sentence, and it's incredibly influential. According to the judge, the report states that Michaela is minimizing her role in the crime. She initially told the investigator no comment, but then later stated, "I feel it needs to be looked into more rather than what they are saying." This is a disastrous statement. It directly contradicts her no contest plea and the defense's argument that she is taking full responsibility. It suggests that behind the scenes, she doesn't believe she's as guilty as the evidence suggests. The judge immediately connects this to the stipulation that she was the one who boxed the victim's car in. Her defense attorney is now in full damage control mode, trying to spin this as just a different interpretation, but the judge's skepticism is obvious.
doing good. She's on my honor roll. Right now she has all A's and perfect attendance since she's been out.
I want to take you back to around the time of the offense. Do you remember getting a call that Michaela have been locked up for some very serious offenses.
Yes, I do.
And can you tell the court what your response was?
That she needed to sit there. I left her in there. She needed to understand what she had done and take responsibility. I left her in there for 5 months before I bonded her out, so she could understand that she didn't do anything, it wasn't something small. She needed to understand exactly what she did and what she could look forward to. She needed to know what prison or their county was, what jail was.
And do you think those 5 months had a significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back. She definitely has a true meaning of what jail is.
And was that your goal at that time?
That's definitely was my goal, because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson, and hopefully we don't ever have to revisit this again, which I don't think we will. I honestly think that she did learn her lesson.
Ms. Franklin, you own a business. Would you tell the judge what you do for a living?
I do. I'm Sugar Glamour Salon, a hair salon in San Antonio.
And have you and Michaela talked about her interest in working in the salon?
Yes, but actually before this, she did. She was my assistant, and to be honest, I need her back as an assistant. But she wants to be a barber, and to get her through college, it'll be something for her to fall back on. And I can. I'm also an instructor, so she can get some of her hours through me.
You mentioned that she's been accepted to UTSA.
Yes, she's been accepted to UTSA, but she's also, we're pending the application for Clark Atlanta, which she preferably would want to go.
Could you address very quickly whether you think your daughter would be a good candidate for probation or deferred adjudication in this court?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. This was.
The defense attorney, Patrick Hancock, is now making a passionate final plea for mercy. This is his last chance to save his client from prison, and he's pulling out all the stops. He reminds the court of the mother's brave approach of leaving her in jail for 5 months, arguing that she has already had a significant taste of incarceration. He holds up letters from her high school, calling them hard letters to get as proof that she is on a positive path. He highlights her acceptance to college and frames this as a crossroads in her life. He directly addresses the judge's concern about her minimizing her role, attributing it to therapy where she is learning not to make excuses. His final appeal is powerful and direct. Sending this young black female to prison will irreparably change her life. He's begging the court to give her a chance to prove herself on deferred adjudication and not become another statistic.
Something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months, and I understand that it's not the same as 10 years, but she definitely recognizes and has had a taste of what jail is, to not do this again and not be in any more trouble, and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Ma'am, that's all the questions I have. The
Okay.
state has an opportunity to ask any questions they want.
Yes.
Any questions?
Were you aware that this offense occurred on February 8th of 2023?
Once I got a call from the Michaela when she was already in custody.
So you knew the date.
Yes,
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was a Wednesday?
I mean, I don't know.
It was a Wednesday.
Yeah.
Would it surprise you that this offense occurred shortly before 1 p.m.?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So do you know, or did Michaela ever talk to you about what happened during this offense?
Yes,
So you were aware that the victims in this case was a mother and her young 4-year-old son.
yes, sir.
And you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of.
The prosecution delivers a chilling and effective rebuttal, shifting the entire focus back to where it started: the victims. The state's attorney immediately counters the defense's emotional appeal with the cold, brutal facts of the case. He states that this wasn't a random act. They specifically targeted a mother and a young child. He emphasizes the lasting psychological damage, stating the child has been damaged for the rest of his life due to immense trauma. He isolates Michaela's role as the critical piece of the crime, the one who boxed them in and made it impossible for them to escape. The prosecutor argues that while her progress after the fact is noted, it doesn't erase the choices she made in that moment. The closing statement is a powerful demand for retribution. The victims feel prison is appropriate, and so does the state. It's a direct challenge to the judge whose trauma and whose future matters more.
The case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here?
I don't think it would be appropriate for Michaela
And ma'am,
for the simple fact.
I'm gonna ask if you
Wasn't-
could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir.
Is it understandable?
It definitely is understandable.
And were you aware that the other two people that participated in this act, that they were both younger than you?
Yeah,
So she was the oldest one out of the group, right?
okay, yes.
So she should have been able to make better decisions than the other two, correct?
I don't agree with that.
This is the moment the entire hearing has been building towards. Judge Boyd is now laying out her thought process, and it is a stark and sobering look at the philosophy of justice. She explains that sentencing isn't just about rehabilitation, it can also be about punishment and protecting the community. Then she delivers the fatal blow to the defense's hopes. She says that sometimes a crime is simply so horrendous that no amount of positive change afterward can erase the need for a prison sentence. She hones in on the single most disturbing fact of the case. The victim screamed that her son was in the car, and it didn't give anybody pause. The judge contrasts this with a hypothetical scenario where carjackers would stop if they saw a child. For her, the fact that they continued the robbery, knowing a child was present and terrified, crosses a line. This isn't about Michaela's future anymore. It's about the fundamental horror of the act itself.
The other two had been in trouble, I understand, and she also was the only girl. So
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver, that's it.
Specifically that boxed in the victim and
I
her son?
understand.
Nothing else to say.
Thank you for coming in. All right, defense, call your next witness.
Judge, that's it.
All right, did your client wish to say anything?
Judge, I think I'm gonna speak for her.
All right, so I want to let the parties know.
Just before the final ruling, the state throws one last grenade, pointing out a massive inconsistency in Michaela's story. In a letter to a psychiatrist, she claimed the two juvenile boys in the car with her threatened her and that she only drove because one of them threatened to shoot her. The prosecutor notes this excuse appears nowhere in the official police report. The defense attorney has to scramble, essentially admitting she felt threatened but stating they are there to take responsibility and not make excuses. This last-minute revelation of a potential excuse only reinforces the judge's earlier point that the defendant may be minimizing her role. It's the final crack in the defense's carefully constructed narrative of accountability. The judge has heard the pleas for mercy, the story of rehabilitation, and the arguments about a bright future. But she has also heard about the terror of a mother and her 4-year-old child, and now a story that doesn't quite add up. The hammer is about to fall.
That part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure.
That was
But
me.
then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility
Mhm.
for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation
Okay,
of her role versus those young men.
all right. All right, anything else from the state? All right.
I don't want to overstep, but I do want to make a brief argument next time.
Yes, you may proceed.
So Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get out of jail? I think Ms. Franklin took a very brave approach for a single mom. And that is that I want her to sit with. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by. And so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from the Roosevelt High School from Ms. Howard says she's really doing well in school. It's hard for me to believe she's 17 years old when I met her and charged with such a serious crime. And she's turned 18 and she's only, 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this because we've spent hours talking about, the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris. And Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. Young people, he specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction and being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path. And we'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what she's gonna have to make going forward. It's something that the state feels that prison would be appropriate here. The victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think have the more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring to court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Barrett County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that that will sway the court in giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem. And what I think people need to look at. Sometimes punishment, and all attorneys will tell you, when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the
Judge,
court.
isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So under, and I'm not trying to argue with the court, but
Mhm.
under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is bothered me, I knew I'd seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing them in. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is.
Well, I don't think it's her feeling. So it's not going to be in a police report.
Right,
But I can tell you that was her feeling on this. She did feel threatened by these 2 young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
No, you're not.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
6 years. The judge found her guilty and sentenced Michaela Johnson to 6 years in the Texas Department of Criminal Justice. In the end, all the letters from school, the acceptance to college, and the 5 months she spent in jail weren't enough. Judge Boyd made her reasoning clear. The act of terrorizing a mother and her young child was so horrendous that it demanded a prison sentence regardless of the defendant's potential for rehabilitation. The judge's decision sends a powerful message that the purpose of sentencing is not always to salvage a defendant's future, but sometimes to deliver pure punishment for the crime and to protect the community from acts that society deems unforgivable. Michaela Johnson entered the courtroom as a college-bound teenager and will leave it as a convicted felon. What do you think of the verdict? Was 6 years the right call? Let us know your thoughts in the comments and subscribe for more in-depth courtroom analysis.